So good morning everyone. There are 7 people who have joined. Good morning Prableen. Good morning everyone. So today we have to discuss the case of Patan Jamal Vali versus the state of Andhra Pradesh, on which is a criminal appeal number 452 of 2021, and on the bench was Justice DY Chandrachud, the next would-be Chief Justice of India. So the date of judgment is 27th April 2021, and this case is regarding a provision of Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. We have already read this so many cases regarding this law, that this law came into being only with the objective of preventing atrocities and various crimes against the members of the scheduled caste and scheduled tribes, because in the Indian society there has been a consistent and calibrated and well-established discrimination against these people, against the members of these two communities especially, because they have been the victims of untouchability since the ancient times. And the Constitution of India has, however, prohibited untouchability in accordance with law, and various provisions and various laws have been made, like the Protection of Civil Rights Act 1955 is one of the laws to protect their interest, social and economic interest. Now this Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989 is one of the important laws, because if any crime or any atrocity or any hostility is conducted against the members of the scheduled caste or against the members of the scheduled tribes, only because they hail from such communities, then this is a social crime, and this has been defined and penalized under this Act of 1989. The law is very stringent, because in most of the provisions there is arrest on a mere filing of complaint without preliminary inquiry. The preliminary inquiry shall take place only after the arrest has been made. So it is so stringent. Okay, and this is also regarding Section 376(1) of the Indian Penal Code was upheld by the High Court. For each of the foregoing offences, the appellant has been sentenced to life in prison, with the substantive sentences to run concurrently. In addition, the appellant has been sentenced to pay a fine of ₹1,000 for each of the offences, with a 6-month jail sentence if he fails to do so. Okay, now this is Section 376(1) and Section 325 of the SC/ST and Prevention of Atrocities Act 1989. Now before we move ahead for reading the facts of the case, let us peruse the two sections. What is Section 3 subsection 2 clause 5 of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989? Is that whoever commits any offence under the IPC, punishable with imprisonment for a term of 10 years or more, against a person or property, on the ground that such a person is a member of a scheduled caste or a scheduled tribe, or such property belongs to such member, shall be punishable with imprisonment for life and with fine. Okay, now if any person is committing any offense which is defined and penalized under the Indian Penal Code with a quantum of punishment of 10 years or more, against a person or property, on the ground that such person is a member of a scheduled caste or a scheduled tribes. Now here the question is, the crime in IPC is Section 376, rape. Okay, rape has been committed only because the woman belonged to either of the two communities. Okay, and this is punishable with 10 years imprisonment. Okay, so whoever commits any offense under the IPC, punishable with imprisonment for a term of 10 years or more, against a person or property on the ground that such person is a member of a scheduled caste or a scheduled tribe, or such property, okay, on the ground that such person is a member of a scheduled caste or a scheduled tribe, or such property belongs to such member, shall be punishable with imprisonment for life and with fine. Okay, and with fine. Now, what is section 376 of IPC clause 1? Whoever, except in the cases provided for in subsection 2, commits rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 10 years, but which may extend to imprisonment for life, and shall also be liable to fine. Now that means if a rape of a scheduled caste or scheduled tribe woman has been committed, and that is punishable with 10 years of rigorous imprisonment, that means the situation squarely falls within the ambit of section 325 of the SC/ST Act of 1989, and hence the perpetrator is liable to face the punishment under section 325 of the Act of 1989. This is very simple. You know, we had to establish the relation between section 325 of the SC/ST Act 1989 and section 376(1) of the IPC. Okay, section 325 says that if any person commits any offense against a member of the SC or ST only because he is a member of the SC or ST, and any offense has been committed against such person or his property which is punishable with 10 years of rigorous imprisonment or even more in the IPC, and that is the case with the rape, section 376. So are you getting my point? You people must be getting my point now. Okay, so the question is that what happened in the case? What happened in the case that this appeal stems from a 3rd August 2019 judgment of a division bench of the Andhra Pradesh High Court. The appellant's conviction for charges punishable under section 325 of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989 and section 376(1) of the IPC was upheld by the High Court. For each of, now conviction was upheld by the High Court. For each of the foregoing offences, the appellant has been sentenced to life in prison with the substantive sentences to run concurrently. In addition, the appellant has been sentenced to pay a fine of ₹1,000 for each of the offences with a 6-month jail sentence if he fails to do so. Now, prior to the incident, the appellant lived in, what happened now? That the appellant was sentenced to pay a fine of ₹1,000 for each of the offences with a 6-month jail sentence if he fails to do so, right? Prior to the incident, what happened? Now, what is the background? The appellant lived in Gajulapalli village and had been doing manual labor for 2 years. He was a manual labor and he used to live in Gajulapalli village. Prosecution witness 2 used to live with her mother. Okay, prosecution witness 2 used to live with her mother, PW1. Now, who is PW1? The mother. PW2 is the, is the person who used to live in the Gajulapalli village and had been doing manual labor for 2 years. Okay, PW2 used to live with her mother and her brother, despite the fact that she has been blind since birth. Okay, PW3 and PW5, this is PW5, are PW1's children. They were also performing manual labor at the same location as the appellant. According to the prosecution, the appellant lived in the same hamlet as PW1 and visited her house on a daily basis since he knew her sons. Okay, they were also performing manual labor at the same location as the appellant. According to the prosecution, the appellant lived in the same hamlet as PW1 and visited her house on a daily basis since he knew her sons. उसके बेटों को, जाहिर सी बात है, वो उसके बेटे मैनुअल लेबर करते थे. They used to do manual labor. So वो पता था उसको, वो जानता था. He used to visit her place. Okay. Now, PW1 was doing her household chores at a public tap within 50 feet of her home at around 9 a.m. on March 31, 2011. 31 March 2011. March 31, 2011. Okay. PW1 was doing her household chores at a public tap within 50 feet of her home at around 9 a.m. and her sons were cutting firewood nearby. The appellant is said to have inquired about her sons, to which PW1 replied that her husband and sons were chopping firewood and asked him to wait. She raced to the house after hearing the voice of her daughter in distress and after half an hour and discovered that the door was locked from the inside. Her husband and sons hurried to the house after she raised the alarm. The appellant attempted to flee by opening the door but was captured on the spot. PW1 noticed PW2 was naked on the ground and bleeding from her genitals as soon as she walked into the house. PW2's garments were ripped and stained with blood. So what happened? What exactly happened? What was this whole scene? The whole scene was that PW1, she was doing her household chores at a public tap within 50 feet of her home at around 9 a.m. on March 31, 2011. And her sons were cutting firewood nearby. The appellant is said to have inquired about her sons. Appellant ने पता किया कि sons कहाँ हैं, उसके बेटे कहाँ पर हैं. Appellant inquired about her sons, to which PW1 replied that her husband and sons were chopping firewood and asked him to wait. कि मेरे जो husband है, मेरे जो पति हैं और जो मेरे दोनों बेटे हैं, वो they are chopping the woods in the forest, and you can wait for some time. They might be coming in a short while. Okay. She raced to the house after hearing the voice of her daughter. Then what happened? Then suddenly she heard the screaming of her daughter. Okay, PW2. And then she saw that the appellant was not there, and she raced to the house after hearing the voice of her daughter in distress after half an hour and discovered that the door was locked from inside. She discovered that the door was locked from inside. Okay. Her husband and sons hurried to the house after she raised the alarm. She started screaming. She started asking for help. So when her screams, they reached to the ears of her husband and her sons, they immediately came back to their place when she raised the alarm. The appellant who was the perpetrator in this case, the person who committed the rape, he was trying to flee. He was trying to escape. So he immediately opened the door and he was trying to rush out of the place, out of the hamlet. But as soon as he opened the door and he tried to escape, he was apprehended by the people on the spot. Okay, and he was captured on the spot. The appellant attempted to flee by opening the door but was captured on the spot. PW1 noticed PW2. Now PW1, who is PW1? The mother of the victim. Okay, the mother of the victim. She noticed that when PW2, that means the victim herself, when the door was opened, she was naked, lying on the ground, and she was bleeding from her genitals. And as soon as she walked into the house, okay, as soon as she walked into the house, what did she see? She saw her daughter lying naked on the bare floor, and she was bleeding from her genitals. And her garments were ripped and stained with blood. This is what she saw. So I guess you must have understood the facts of the case. Any confusion in the facts of the case up till now? Okay. Clear. Okay, so thankfully, fortunately, you have understood the facts of the case. They're very simple. There's no complication involved. Okay. No complications. Now PW2. PW2, who is PW2? The prosecution witness 2. Who is she? The mother of the victim. I'm sorry. PW2 is the victim herself. PW2, who is PW2? The victim herself. You can read the facts again and make sure that you correctly understand who is PW1, who is PW2. PW2, the prosecution witness 2, is the victim herself, is said to have stated under questioning that the appellant came to the residence and inquired about her brothers. He then shut the door, fell on her, gagged her and raped her. That's what she described and narrated. She narrated the whole incident, what actually happened with her. She was trying to explain it categorically and eventually that like what happened with her, that she stated when she was questioned that she was asked to narrate the whole incident, what she has been through. The appellant came to the residence. She stated that he came to the residence. He inquired about her brothers from the mother. He asked her that where are her sons and his husband and her husband. She said that they are chopping the woods in the forest and they might be coming. You can wait for a short while. He then shut the door. Then when he was assured that no one is at home and these three people, the three male members are already out. Okay. Then he then went inside, came inside the hamlet. He then shut the door. He then fell on her, gagged her and raped her. The prosecution claims that around 10 a.m. The prosecution claims that around 10 a.m. the Mahanadi Police Station Sub-Inspector of Police. The prosecution claims that around 10 a.m. the Mahanadi Police Station Sub-Inspector of Police, who is prosecution witness number 9 in this case, received a call from prosecution witness 4. Okay. Now, who is prosecution witness 4? PW1's cousin. That means PW1's cousin. जो माँ है victim की, उनके cousin हैं PW4. PW4 कौन है? Who is PW4? जो PW1 है यानी कि victim की mother है, उसके cousin है, उसके भाई लगते हैं. Okay? Cousin है. तो यानी कि victim के वो मामा हुए, his uncle, her uncle. Okay? So the prosecution, maternal uncle, the prosecution claims that around 10 a.m. the Mahanadi Police Station Sub-Inspector of Police, who is the prosecution witness number 9, received a call from prosecution witness 4, who is PW1's cousin, and rushed to the location. He immediately, when he received to the call, the sub-inspector immediately rushed to the location. The locals handed over the appellant. Now, since appellant was apprehended on the spot, so the locals, they handed over the appellant to the circle inspector of the police. Okay. Nandyal Rural Police Station, who had arrived at that time. Now they immediately handed over the appellant to the circle inspector of police, Nandyal Rural Police Station, who had arrived at that time. Now PW1 filed a written report with the police. Now that's a formality which is needed. That PW1 filed a written report with the police, the mother of the victim, which was assigned the number 28 of 2011. PW11 took the victim to the government hospital, where she was evaluated by PW10 to the district hospital civil surgeon. Now who is PW10? District hospital civil surgeon. PW2 was blind. Okay. According to the medical evaluation, when she was medically examined by the prosecution witness 10, that means district hospital civil surgeon, she was discovered to be blind. Okay. and she was thoroughly examined medically. Okay. Then first, the sessions judge convicted the accused, and later the High Court upheld the conviction. The sessions judge convicted the accused, and later the High Court upheld the conviction. Now, against the conviction, the appellant, that means the perpetrator, but he has come in an appeal before the Supreme Court. This is a criminal appeal against the state of Andhra Pradesh, against the conviction. Okay. So have you understood the whole trajectory of the case? First, he was convicted by sessions judge. After perusing and considering and reckoning with all the evidences, the sessions judge convicted the accused, and later the High Court also upheld the conviction. So as a matter of right, the perpetrator in this crime, the appellant, came in an appeal, the convict came in an appeal before the Supreme Court against the state of Andhra Pradesh, against the order of the conviction. So have you understood? Understood or not? Okay. Any question, anything that you want to ask right here before we move on with the issues of the case? Let us first try to find out if there is any ambiguity lying over it. Understood. Everybody has understood. Now, issues. Whether the appellant is guilty of the offence under section 325, 3 subsection 2 clause 5 of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. Whether the appellant is guilty of the offence under section 376(1) of the IPC. Now, why this provision has been brought into question? Why Scheduled Caste, Scheduled Tribes Prevention of Atrocities Act 1989? Why not simply he was convicted for rape under section 376? Why this law? Why this law, section SC/ST Act of 1989? Because the girl belonged to the Scheduled Caste community. She was then raped. So the matter squarely falls within the ambit of section 3 subsection 2 clause 5 of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. Okay. And along with this has to be read in along with section 376(1) of the IPC. Okay. Laws involved: section 3 to 5 of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. We have already read this, that whoever commits any crime which is defined in IPC and penalized in the IPC, which is punishable with which is punishable with 10 years of rigorous imprisonment or even more, against a member of the SC or ST, then the matter would squarely fall within the ambit of section 3 subsection 2 clause 5 of the SC/ST Act of 1989. What does section 376(1) of the IPC says? That whoever commits rape, not falling in the cases as described under subsection 2, shall be punishable with rigorous imprisonment of 10 years. Okay, not less than 10 years of rigorous imprisonment. And then Article 15 clause 1 of the Constitution of India. Article 15 clause 1 of Constitution of India expressly prohibits discrimination against any person on the basis of religion, sex, caste, place of birth, color or religion. Okay. This is prohibition of discrimination. Now this is an SLP. What is an SLP? Special leave petition. We have the provisions for criminal appeal, we have the provisions for civil appeal, And then we have the provisions for constitutional appeals also. They are in Article 132, 133 and 134. Okay. But Article 136 of the Constitution of India, this is regarding special leave petition. Special leave petition is that before a special leave petition is filed, two things are supposed to be established. That means one is that there is a substantial question of law involved in the case, and this substantial question of law is of public importance which needs to be decided by the Supreme Court. Now, if these two essentials are satisfied, then SLP can be admitted. Otherwise, it will be simply dismissed by the Supreme Court straight away. Special leave petition, you must have all read this provision in your BLLB programs, that Article 136 of the Constitution of India talks about special leave petition. And two things are supposed to be established: that there is a substantial question of law involved in the case. You can only file an SLP in a case where there is a substantial question of law of public importance involved in the case, and such substantial question of law needs to be decided by the Supreme Court. That's it. These are the two things. Now, in this SLP, learned counsel for the petitioner. The petitioner means that the person who committed the rape, he has come in an appeal before the Supreme Court against the state of Andhra Pradesh, for setting aside, for getting the order of conviction null and void declared by the Supreme Court. Okay. Learned counsel for the petitioner argued that an offense under this provision has not been established because of the expression on the ground that such person is a member of a scheduled caste or scheduled tribe in section 3, subsection 2(5) of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989, which has been interpreted in this court's decision. As a result, the imposition of a life sentence in connection with an offense under section 376 of the IPC was not legal. Now, the lawyer for the petitioner, the advocate for the petitioner, he was trying to defend his client. He was trying to do his job simply. And the argument he put forth before the Supreme Court was that, this case is not made out under section 3, subsection 2, clause 5 of the SC/ST Act of 1989. Because the petitioner did not commit rape only because the victim belonged to the scheduled caste. वो scheduled caste से थी इसलिए उसका रेप किया, caste atrocity थी इसलिए उसका रेप किया, ऐसा कुछ नहीं था. Okay. So as a result, the imposition of a life sentence in connection with an offense under section 376 of the IPC was not legal. Because if section 3, subsection 2, clause 5 of the SC/ST Act of 1989 is read with section 376 of the IPC, the total punishment increases to life sentence. Although the total punishment, the maximum punishment under section 376 is rigorous imprisonment for 10 years. But when these two sections combine, the quantum of punishment increases to life imprisonment. So the advocate was trying to defend the petitioner on the ground that he might have committed the rape. And he should be then convicted simply under section 376 of the IPC for committing the rape. But he should not be convicted under section 3, subsection 2, clause 5 of the SC/ST Act, because he did not commit rape as a matter of caste atrocity. He did not bear any caste atrocity. He did not bear any atrocity, any hostility against the victim only because she was a scheduled caste. He committed rape because he was, allured by, he must have, like, there must be some biological reasons other than this. Okay, other than this, he committed the rape. But he did not commit it by thinking. He was not provoked by this any caste atrocity. He was not prompted by any caste atrocity or caste hostility. He was not trying to commit rape only because the victim belonged to the SC community. only because the victim was a scheduled caste. No, that was not the case. So he was trying to dismantle the whole case that was made out by the sessions judge by the Andhra Pradesh High Court under section 325 of the SC/ST Act of 1989. Okay, now these arguments must be very clear. And what are the arguments for the respondents? For the state of Andhra Pradesh, the state of Andhra Pradesh was trying to put forth all those arguments which it had put forth in the High Court. In the High Court, there are witnesses, there are so many witnesses: the mother of the victim, the brothers of the victim, the mama of the victim, the maternal uncle of the victim. Okay, there are so many locals around, in and around the hamlet of the victim. Okay, there are prosecution witness 9, there's prosecution witness 10, there's prosecution witness 11. There are so many people who are bearing this testimony that this man, Patan Jamal Vali, committed the rape. Okay, so all the evidences needed to be reperused again at by the Supreme Court. Now the judgment. The court, citing the case of Navtej Singh Johar versus Union of India 2018. Now the Supreme Court gave reference to this case of Navtej Singh Johar versus Union of India. Do you remember this case of Navtej Singh Johar versus Union of India? Do you remember the case of Navtej Singh Johar versus Union of India 2018? Very famous landmark case. The case in which the Supreme Court decriminalized section 377 of the IPC. Okay, and this case was used as an intersectional lens to look at Article 15 Clause 1 of the Indian Constitution, which safeguards against discrimination. Since there was a calculated and calibrated and categorical discrimination against the members of the LGBTQ community in India. So this case was used as an intersectional lens to look at Article 15 Clause 1 of the Indian Constitution, which safeguards against discrimination. Okay, the court determined that so far as when we are talking about prohibition of discrimination, we are talking about equality. We have to look at cases like Navtej Singh Johar versus Union of India. Okay, the court determined that intersectionality refers to oppression that results from a combination of numerous oppressions that when combined produce something distinct from other forms of discrimination. Okay, the court went on to say that while some steps have been taken throughout time, they have been too little and too far, and they have not attempted to rebuild and reform society and its institutions. But the state must ensure that no woman is discriminated against because of her caste or religion. What did the court say? The court went on to say that while some steps have been taken throughout time, they have been too little and too far, and they have not attempted to rebuild and reform society and its institution, but the state must ensure that no woman is discriminated against because of her caste or religion. Okay, now the Supreme Court was trying to emphasize on this point that almost like so many things have been done for the sake of women in this country. We have the Vishaka guidelines, we have the Criminal Law Amendment Act of 2013, we have recently the guidelines for the protection of honor killings was sought from the Supreme Court in Shakti Vahini versus Union of India, right? And there are so many things, but they are still too little, and we are still, we need to traverse a very long path so far as women's rights are concerned. And we have to work on one very specific thing. And what is that? That women quite often, they are discriminated against because of their caste or religion. Okay. So the court also cited the Justice J.S. Verma report. What do you remember? The Justice J.S. Verma committee, which was formed right after the 2012 Delhi gang rape case. when Nirbhaya was raped on the 16 December 2012, which shook the conscience of the entire nation, in fact the whole world. Okay, so escalate means बढ़ना, escalate होना, किसी मसले का बढ़ना, ठीक है, aggravate होना किसी भी चीज का सक्षम. Okay, the court went on to say that while some steps have been taken throughout time, they have been too little and too far, and they have not attempted to rebuild and reform society and its institution, but the state must ensure that no woman is discriminated against because of her caste or religion. The court also cited the Justice J.S. Verma report, which was created in the aftermath of the Delhi 2012 gang rape case, in describing how prejudice induced by intersecting identities escalates violence against specific communities, genders, religions, and other groups. Because we have deep-rooted prejudices against each other, and these prejudices are based on caste, they are based on religion, they are based on genders. We do not tolerate women who go out and do something for themselves and for their family. There is a well-established prejudice against the girls who want to do something in their life, and this well-established prejudice, this prompts these kinds of perpetrators in the society to commit crimes against women. They don't want them to come out and step out of their house. Okay, so there is a prejudice, and this is induced by intersecting identities that escalates violence against specific communities, genders, religions, and other groups. The court also reviewed the status of women in modern Indian culture, concluding that while laws are being passed to bring about change, more effort remains to be done to ensure that the laws benefit the goal for which they were passed. Okay, for which they were passed. That means laws are being passed to bring about change, obviously, and more effort remains to be done to ensure that the laws benefit the goal for which they were passed. Okay, finally, what happened? The court looked at section 3 subsection 2 clause 5 of the SC/ST Act. After finding no essentials under the section, it threw aside the judgment and upheld the accused conviction under section 376(1) of the IPC. That means section 3(2) clause 5 of the SC/ST Act was set aside. In this case, the conviction of the accused under section 325 of the SC/ST Act was set aside, and he was convicted under section 376 clause 1 of IPC, because perhaps the advocate of the petitioner was successful in convincing the court that he definitely committed the rape, but this rape was not prompted by any prejudice against the caste. He simply did it because he found this opportunity. He would have raped any other girl who would have been in her place, belonging to any community. For him, her caste, her religion, her identity was completely immaterial. Okay. Okay. So Chitralekha says Justice Leela Seth was one of the members of the committee. Okay. Yes. Chitralekha. Okay. So the advocate of the petitioner, I am repeating this again, the advocate of the petitioner was successful in convincing the court, that he did commit rape, but this rape was not prompted by, and this was not induced by, any well-established prejudice against her caste or community. He could have raped any other girl belonging to upper caste. For her, her caste, her identity was absolutely immaterial. So his conviction under section 3 subsection 2 clause 5 of the SC/ST Act was set aside, and he was simply convicted under section 376(1) of the IPC. Okay, so you must have got it. Any confusion? Yes, Somesh. Victim in this case was blind. Victim in this case was blind. No, Taran, victim's mother was not blind. She saw her daughter lying on the bare floor naked, and she saw her bleeding from her genitals. So victim's mother was not blind. Victim was blind. So read the facts again. See, when she was read the last line. PW11 took the victim to the government hospital, where she was evaluated by PW10, the district hospital civil surgeon. PW2 was blind. PW2 is the victim, not the mother of the victim. She is PW1. According to the medical evaluation. Sumesh is asking, since she is blind, then shouldn't she get extra compensation or benefit? Obviously, we have victim compensation scheme under CRPC. We have this victim compensation scheme under CRPC. The victims of these kinds of crimes are compensated according to their status and according to the crimes they have been a victim of. Okay, so a victim compensation scheme would take its own course accordingly. However, that is not a subject of discussion here, that what is the victim compensation scheme and how is she going to get benefit from this. Okay, since she was a blind, then she would get the compensation accordingly. The victim compensation scheme under the CRPC would take its own course accordingly. Okay, shall we? So he was convicted for life or 10 years. 10 years. Okay, not less than 10 years or more. So the punishment could have been anything, but it was less than life imprisonment. Okay, 10 years. Chitralekha says, so this is also a case where police do not put sections properly and they blindly find out that there is a crime and the victim is of one caste or class and simply add the sections. Yes, this has been a regular practice on the part of the police, that they immediately use the sections of SC/ST Act 1989 once they find that the victim hails from a particular community. They don't try to find out that whether the crime was committed in a general manner or was it committed actually because as a matter of caste hostility. Okay, so they don't put these efforts to decipher this. That's true. Without actually looking into the matter and see if a particular section is applicable or not. Yes, exactly. Okay. So, any other question? Okay then. I am ending the live stream now. We'll meet with another case tomorrow. Okay? Thank you.